So glad to have this opportunity to talk about gray divorce in Illinois. I have been a huge supporter of Elderworks for many, many, many years and love the work that they do. And I'm glad that they offer this opportunity to the community. I'm Liz Wakeman. I am the owner of Wakeman Law Group in Crystal Lake, and I also work out of Inverness as well. So I've really covered the Northwest suburban area for divorce sort and other family law issues. The if you can see my screen, I will start talking a little bit about what gray divorce is and what it means to you. It's very, very marked trend that people over the age of 50 are getting divorced more. The divorce rate for adults over 50 has nearly doubled since 1990, and it's among adults over 65, it's nearly tripled. So it's more and more common that you will find people who are waiting until their children have grown and they're heading into retirement before they go into a divorce process, even though in many cases the uh, idea of divorce has been percolating for quite some time and they're just waiting for the next thing to happen. So I'm going to first suggest that in most circumstances, that waiting does not give you the results that you usually want. It very rarely can, but it doesn't usually make it more amicable or more simple. And very often I hear children of the gray divorce people saying, I wish they'd done it sooner. So if you hear friends who are thinking about this, and I'm certainly not an advocate of divorce, but I do think staying in it for lots of reasons is maybe not necessarily the best choice. One of the things is that when you're getting a gray divorce, it becomes a little bit more complicated. So Illinois is a no-fault state, which means that the only ground for divorce is irreconcilable differences. That there is no claim about adultery, abandonment, or anything along those lines, and it hasn't been for many years. Um, the bottom line is the issues shift from children to money and to figure out what your future plans will be monetarily. And then very often we end up seeing second marriages. So the issues about prenups and going to the next step are also very important. So things that apply to all divorces. Money, when you're talking about property division, the range is a very narrow range. It's generally going to be, the statute says equitable, but that can mean 50-50, 45-55, 60-40, but it's rarely more than the range of 50-50 to 60-40. So it's a really good idea to get a handle on what those total assets are and decide how much money am I going to spend to get maybe an extra 5% of the total. And obviously that matters whether you're going to be spending $10,000 to get 500,000 or to potentially get less than what you're spending. Out of court is always better. This applies to all divorces. And there are so many opportunities right now, particularly the idea towards collaborative and mediation and doing alternative ways of getting a divorce are very, very prevalent right now. And there's a clear trend. And the trend is because it makes the most sense. You get better results if you're doing this sort of process out of court, more amicable. You don't have to rely upon a judge arbitrarily deciding something based upon incomplete facts. It causes less anxiety than if you have to go to court. And there are more alternatives available to you for how to divide things. If you do things out of court, a judge is going to be limited in what they can do. You and your spouse can do a lot of things to be more creative and more flexible to meet your specific needs. So the out of court options, there's mediation, which is you sit down with either a mediator or you can sit down with two people and two attorneys to try and negotiate who should get what and who should pay what. Those conversations are so much better if you have the two of you and two attorneys doing that conversation, because the two of you are not going to be able to likely reach an agreement on your own, or you would likely not be getting a divorce. You are going to be the last person your spouse will be listening to at this time, and they're not going to listen, and you're not going to really listen to what they want either. So if you can have the attorneys who are knowledgeable about what the law is and who are committed to helping you get a case settled, that is the fastest and easiest way to resolve a case. You can also go to a third-party mediator with a neutral person will help guide the mediation. My experience in family law is that it's better to do that with attorneys because the most dominant personality can often bully in a mediation, and the result can be um, you end the mediation, you think you have an agreement because the more dominant spouse says, this is what we're doing. And then an attorney looks at it and says, this isn't really a good idea. Um, the other thing that applies to all divorces are fear and anxiety. And all the different worries that come with how am I going to go into this next chapter? Uh, what does that look like to me? Few things to start off on the best foundation. Stay in the home that you live in with your spouse until the divorce is final, if at all possible. Obviously, there's an exception if there is violence or abuse, but staying in the home makes divorces go much more quickly and are much less expensive. Once someone moves out, things change quite a bit and it becomes more difficult. This is not the time to have an argument with your spouse. There is nothing you can say that's going to change them or make them different than how they have been. And you, in the gray divorce area, probably have been with someone for a very long time and know better than anyone when your spouse is not going to listen to you. And that time is definitely when you're thinking about divorce. The risk that comes with having an argument is that it explodes and it escalates to the point that police get involved and someone does have to leave the house. And then that becomes much more complicated and much more filled with anxiety and stress and emotions. And the other thing that you can do to relieve your fear and anxiety is to talk to an attorney sooner rather than later. Many people will wait until the petition for dissolution of marriage is filed with the court and someone has been served to call an attorney. The time to call an attorney is long before that. It's when you are first starting to think, this is not where I want to be for the next 10 years and the rest of my life. Because the attorney can help you build the foundation and get all the ducks in a row and everything lined up so that you are in the best position to proceed with a divorce process. Um, the later life divorce is different than all the things I just discussed about what applies to all divorces, and that is it's focused more on money and not about the children. But I'm surprised at how often children's issues still do come into play, particularly if you have a child who is disabled in any way. That is going to remain, and we'll discuss that in a little bit down the road. Um, that will remain an issue potentially for support issues. Um, the bigger arguments now focus on how to divide retirement accounts and the financial, how to divide debt. Um, when you're getting a divorce, when you're later in life over 50, you have a shorter runway. You have less time to recoup, recapture, or rebuild than you do if you're getting divorced when you're 30. Um, so it's more important than ever to speak with a financial planner to make sure you're using your resources most wisely to plan for retirement and to plan for your future care because you don't have as much time to recover financially when you're getting divorced at 50. But you definitely still can. I definitely have people who have gone through their great divorces who are so much happier and actually feel empowered because they have now control of their own financial future rather than being dependent upon someone that maybe wasn't so reliable. And then the longer term of marriage will have a few different implications in the finances. Number one, it's more likely if you've been married for 20 or 30 years that you have commingled or transmuted assets. Commingled is when you take something that was a gift or an inheritance or something you had before marriage and put it into the same account as you're putting your current paycheck, or that you're putting a tax refund. Commingled, once it's commingled, it's mixed up and it's no longer then considered premarital or non-marital, even if you did have it before marriage. And transmuted is another word for the same thing. I'm just giving you these words so you know them when you hear them. The transmuted means it's been transformed from a premarital to a non-marital, or premarital or non-marital to a marital asset. When you're getting a divorce, it's the marital estate that gets divided. So if you have assets you had before marriage. Maybe you have a retirement account or a pension from your first job when you were in your 20s, or you may have an inheritance or some gift money that's come in from a family member. If those items are kept separate and in your own name, those are not then divided in the divorce. So this is another point about when you're getting a divorce after 50, you may have a situation where your parents and other relatives are passing away and you're receiving an inheritance. It's extremely important to talk to a financial planner or an attorney. Most importantly, it's important to keep those funds that you inherit or are given as a gift must be kept separate and in your own name, or they become marital property. The other part of how the term of the marriage and length of the marriage matters is that the longer you're married, the longer the term is for payment of maintenance, which is formerly known as alimony. And we'll get into that in a little bit, but the time of the marriage matters at this point. So the maintenance issue, it used to be called alimony, and this is spousal support. This is very often the focus of a divorce proceeding when someone's over 50. So the first question that you and your attorneys, I talk about what the court will look at. When you talk to attorneys, the attorneys should be able to guide you about what the court will do so that you and the attorneys can get it done and not have to have the court weighing in. But we'll look at what the statute provides. There's a statute that expressly defines what has to be considered with respect to maintenance or spousal support. So there's a list of factors about what your contribution to the marriage was, for example. Very often with a gray divorce, we have somebody who was out of the workforce for a long time and stayed home and took care of children, and their spouse is saying, you didn't contribute, I earned all the money, it's my money, I put it in my name, it's not yours. No. In Illinois, the statute says both spouses are presumed to have contributed equally. Presumed is an important and big word. It means somebody has to prove you didn't contribute. And proof that you didn't contribute would not be, I stayed home and took care of my children. If you stayed home to raise your children, you are presumed, the court will assume that you have contributed just as much as your spouse did, albeit in a different way, with one bringing in income and one taking care of the household and children. The court would also, one of the standards is also to look at the standard of living. Did you live in a 2,500 square foot house, or did you live in a 7,500 square foot house? Did you always have four cars, or did you always manage with one car? And what are your different health issues? What would be an impediment to earning some money going forward? The factors outline a percentage of there's a multiplier of the number of years of marriage that is multiplied by the length of the marriage with this multiplier, and it determines how long you'll have to pay or how long you'll be able to receive maintenance. And another important note, because you might have friends who got divorced a long time ago, in 2019 the law changed so that now spousal support and maintenance is not deductible and is not taxable. So that will be tax-free income to the recipient, and it's not tax deductible to the person who's paying it. The maintenance statute also states that if a marriage is 20 years or more, that the court will order what's called indefinite term, or less frequently a period equal to the length of the marriage. I actually never see that phrase really used in final decisions, but the indefinite term, which means that indefinite will go until the person who's paying maintenance has stopped earning income, or does not have assets and income available to pay maintenance any longer. So we'll come back to that in a minute to go more into what's an indefinite term. Um, so when when you're looking at a gray divorce, you're looking at somebody's going to maybe retire sooner rather than later. And here we have the threat. I'm going to retire, so I won't have to pay you maintenance. That threat does not necessarily work as well as the person who's saying it thinks, the one who's making the threat thinks, because the court would, in deciding whether someone has to continue to pay maintenance, they're going to look at whether somebody's retiring in good faith. So maybe you always did plan on retiring when you were 55, but now if he's retiring at 55 and he's not going to be able to pay maintenance, he will say because he's not earning income, the court would look at that and say, yeah, you probably have to keep working because you do have to keep paying maintenance because the spouse needs spousal support to be able to support their own needs and pay their rent or mortgage and their bills. Um, if someone um, has terminated or forced to retire or fired from their job, the court would look at, was that done because the employee, maybe your husband or your wife, was deliberately sabotaging their job so that they wouldn't have to keep working, so they wouldn't have to pay you. The court would look at that employment file and would look at that evidence to determine if maintenance would continue or not. Just because someone stops working or retires does not mean that maintenance would end. I actually recently had a case that went up to the appellate court on this issue, and um, I was able to demonstrate that somebody who still had income and assets available to support their lifestyle in a very grand way when my client was living a very simple life, that the maintenance was going to be required to continue. Um, the what the legal standard that a court would look at and that good lawyers would look at when deciding if maintenance should be um, terminated with retirement is going to be if it's a substantial change, whether it was in good faith, and they'll look at the actual implications of what the income stream will be to each party. As I discussed before, dividing the property is divided based upon equitable and not equal. So it's not necessarily 50-50, but we do sort of start at that point. And that does not include money that you have from an inheritance, doesn't include money that you may get in the future from an inheritance. And the it's going to be really important to keep good paperwork on this. This is where the gray divorce is more complicated because we did not have electronic downloads of all of our statements 20 years ago. And so the next generation will have a much more simple time of going back and retrieving all of their records. But if you had a 401k or a pension from before marriage, and it was purely before marriage, and you never put any money or never made any contributions during the marriage, that would be assigned to the person whose name that's in. And that would not be considered part of the marital estate or what's being divided. But if you have a 401k that you contributed to a little bit before the marriage and then all during the marriage, that's likely going to be considered to be marital, and that's going to be probably, if it's a 401k, divided equally. But if it's a pension, it's going to be divided with something called a Hunt formula. And the formula for a pension is you'll take the number of months of the pension that was earned during the marriage, the number of months that there was a contribution during marriage, divided by the total months that the pension was in effect. So that means that that division applied to the pension, and then generally speaking, times 50% is the amount that the recipient would receive in dividing the pension. The practical result of this is if someone is a teacher or a firefighter and contributes before marriage, the contributions before marriage and the benefit that came from that would go purely to the person who earned that pension. Um, Social Security cannot be addressed or divided in a divorce court or a marital settlement agreement at all. The marital settlement agreement is the contract effectively that we put together that creates the final agreement that's going to be entered by the court for divorce. Social Security will not be addressed in that. And so divorce attorneys cannot give advice about Social Security because it's not part of um, what we can address in the state of Illinois. But we can tell you that the Social Security income will be considered in determining the payment of maintenance. And I can tell people, as I always do, go to the Social Security office and talk to them. And sooner rather than later is a good idea for doing this because very often a spouse can receive the Social Security benefits based upon their spouse's earnings record, which is particularly important for someone who was at home raising children and taking care of the household and didn't have contributions to Social Security. You will be able to receive a Social Security sum based upon your spouse's earnings. But there are limits and there are requirements and rules. So please check with Social Security to get more details on that. And I don't give information about that because it also changes all the time, and I can't stay up to date on Social Security regulations and the what the federal government is doing. The very dramatic concern with divorce when you're over 50 is health insurance. So the first and easiest thing to do is if your spouse has insurance coverage, you can be on their insurance coverage for 36 months, but it's full premium plus 2%, so it's more expensive than getting it in other places. Um, The troubling part, especially early in my career, was what happens after 36 months if that gets you to like 60, and what do you do for the next 5 years and insurance wasn't available. But we do now have insurance available in the marketplace, and that also has a lot of rules involved with that, but you can get that insurance coverage to bridge the gap until you get to be Medicare eligible. And again, I would talk to someone at Elderworks in particular regarding the terms for Medicare and what you need to know because that's not my expertise, but I do know that a divorced spouse can qualify for premium-free Part A based upon their spouse's work history and earnings history. The other thing that is looming when you're over 50 and getting a divorce is what's going to happen if I end up having a memory care issue or if I start to have problems with an autoimmune disorder so I can't move as well and I need some help. Really important to speak to someone from Elderworks or another financial planner to look into what your alternatives are for how to plan for long-term care. We're living longer, which is wonderful, but it comes at a cost. Um, so hopefully you have an estate plan, you have a will and a trust and powers of attorney prepared so that all of your affairs are in order. My experience, however, is most people don't. So first thing to say about this is get your estate plan put together. And while I don't do estate plans other than I do it for my divorce clients, um, really important, not very expensive, worth every penny, will save you so much money and so much time if you have a solid estate plan than having to go through probate and waiting for um, statutory times to pass before money can be distributed. But you need to know that whatever is in those estate plans are they revoked automatically at the time of the divorce. So if you have a power of attorney for healthcare that was prepared before the divorce, you get divorced, that is now revoked. Your former spouse will not be able to make your healthcare decisions. So you definitely need to update all of your estate planning documents to name new people because what you already have in place will not be valid any longer. You can, however, after the divorce, rename your former spouse if you want them to be the person who's going to make some decisions for you, which is very often the case that people can remain friendly and in touch and things, and that former spouse is the perfect person to make decisions. You can redo it after the divorce and name that person and clarify that they're your former spouse. but a prior document will not be valid any longer. Very, very, very important to go and check if you once you get the divorce completed, um, to make sure your beneficiaries are updated for life insurance, IRAs, 401ks, pensions, everything you have. You might even have a financial account that's in joint tenancy. Change it. You need to change these things right away. And it becomes more important when you're over 50 to get those accounts changed and updated. Excuse me. Um, so especially with the increase that we see in neurodivergent issues in people's healthcare in the recent years, if you have an adult child who's not able to support themselves, then you can arrange in a divorce proceeding to have support paid so that both parents are contributing to the support of that child who might have a disability. That's a whole other seminar. I just gave a seminar to the Bar Association about this. There's a lot to it, but if you have questions about how to provide support for an adult disabled child, let me know. And also, again, Elderworks can help you with that, I believe, as well. Um, the other issue to consider is capacity and influence. So if you notice that your spouse is starting to become more forgetful to the point that maybe they could be having dementia or having other impaired decision making, it is really important to act sooner rather than later and not just think it's all going to be okay. Because if you go to divorce someone who has dementia, it's more complicated because there would have to be a guardian appointed for them. It's very complicated. I did experience this with a case many years ago where the wife was experiencing her husband becoming more abusive and more aggressive, and she just thought it was that he was being, a jerk. But it turns out he wasn't being a jerk. He had dementia that was causing him to act in ways that he would have never acted before. So while she just thought he was changing and not being a good husband anymore, he in fact was diagnosed with dementia, and there was a guardian appointed to take care of him as she was trying to divorce him. Um, so if you were seeing signs of dementia, it's important to act sooner rather than later. Um, that's where if you have the power of attorney for healthcare, you might want to act on that and get a guardian appointed for your spouse before you get a divorce. Or you may want to get a divorce and reach out to one of their family members and say somebody needs to get guardianship for this person because they're not thinking clearly or acting correctly, and there needs to be some help. Um, but the worst case scenario is there's a power of attorney that names a spouse, and then dementia comes in, and there's no clear person that would be the guardian if you're divorced and haven't addressed this. Um, Medicaid and long-term care, a very important issue to consider when you're getting divorced over 50. uh, Strongly urge you to speak with Elderworks and Medicaid experts because again, that's like Social Security changing all the time. But the spousal impoverishment planning can interact with the settlement, and you want to make sure that you do this correctly and properly so you don't sell an asset when someone's going to be going into long-term care and then that sale violates or eliminates them from Medicaid eligibility. There are so many factors to consider with this when you're getting a divorce over the age of 50. Um, if somebody, when you've been married a long time, or when you're at 50 or 60 years old, or 70 and 80 years old, if somebody's had a family business, that value of the business is going to be very, very important. There are professionals who will evaluate the business with a very complex analysis. Well worth it if you have a long-term family business to have that evaluation done, because in most cases, that business that you and your spouse built from the time you were first married um, is a marital asset, and you need to be able to get the equitable portion of that business, Or if you're the business owner, you need to prepare to be giving up or buying out your spouse for what that business value is. Um, this is some of the deadlines that matter. Um, the deadline, the 10 years of marriage delivers Social Security benefits. So when you're talking to an attorney about filing for a divorce, you probably don't want to get divorced when you're 9.5 years into the marriage. And that the timing also matters with maintenance because if you wait for that next anniversary, you get bumped up to a higher amount maintenance that you have to pay or that you will be paid. So the 10 years is a big mark, and then 20 years is the next big mark. And for the maintenance issue, it looks at what the date of the filing of the process is. And for Social Security and Medicare, it usually would be the time of the divorce being final, but that could change. So check with your Social Security and Medicare office. Um, these are important things to just check off. Don't assume that when you get divorced that your spouse is going to take care of anything. It's not their job. It's also not your job to take care of their checklists. You're each going to be every man for themselves. And as you're updating and correcting car titles and deeds to vacation homes, titles on a wave runner or a boat, really be very, very careful to address every single asset that you have and make sure that you enroll in healthcare in the enrollment periods when they're open, and it doesn't require special enrollment. And build a team, build a group, have a family lawyer, have a financial analyst, have an accountant who's able to help you with your tax documents, and definitely have a strong estate plan. The um, best way to get a divorce, whether you are 20 or 60 or 80, is to have a good team to be working with you and doing the fundamentals of the divorce. The um, some of the documents and some of the laws really do need like the particular software that attorneys have that we use to calculate what maintenance would be, that we can use to look at what support for an adult child who's disabled might be, and we can refer you to the right resources. One of the most common questions I receive about retirement is who's going to be responsible for the taxes. Is attorneys are not allowed to give tax advice. You need to talk to an accountant about that. But there are some important things that I can say overall. When you're dividing retirement accounts and you want to not you don't want to pull all the money out and have it all taxable at once. That would be a financial tragedy. We do retirement of retirement accounts, division of retirement accounts with something called a qualified domestic relations order or a qualified Illinois domestic relations order, which is quadro and quildro. The quildro will apply um, if you have been a firefighter, a teacher, county employee, police officer, then that would be the quildro. Otherwise, it would be a quadro. So if you're an Illinois state government employee, the quildro will apply. The division is done in the marital settlement agreement. The marital settlement agreement will say that this pension will be divided equally between the parties or 50-50 between the parties. And then we contact the administrator of the retirement account and work with them to get a form put together that's an order that is compliant with all federal and Illinois law to tell that administrator how to divide that account. We then have it submitted for review by the administrator, reviewed by the attorneys, reviewed by the court. Once there's a court order entered, that's the qualified domestic relations order or quildro. The administrator will then segregate the account, and the administrator will do the division so that there is no tax consequence for that transfer at the time of the divorce. And then each party would have their own portion, their own proportionate share of what's in those accounts. And then when you go to retire or when your spouse retires, you can then withdraw money, and you withdraw money that is going to be taxable at your income rate, at your income level when you take the withdrawal. So those quadros and quildros are very important. That's the only way you can divide a pension or a 401k. It's important to get that drafted at the time you get your divorce, because if someone dies or becomes incapacitated, it's more difficult to get that entered. And it's important to have an attorney draft those documents who knows what they're doing and has worked with the different administrators and different uh, institutions before. It's important to not put that off. And that will save a lot of money, and it will prevent what I saw early in my career was someone just went in and cashed out their 401k and divided it so that there was this gigantic tax obligation because they thought that they didn't need to talk to an attorney about this. It's so important to get this right.